My name is Donna Bales, and I'm the founder of the Canadian Regulatory Technology Association, and I'll be your host and moderator today. For those of you who do not know the Canadian Regulatory Technology Association, we're a not-for-profit focused on bringing the industry together to talk about key topics around regulatory challenges and how RegTech can solve them. Our key stakeholder group is comprised of financial service institutions, RegTech firms, and the regulators themselves. This session today was kindly sponsored by Data Sentinel, and Mark Rowan, the co-founder of Data Sentinel, is here with us today. And the session is part of our RegTech Week suite of programs. Today, we're going to set the groundwork by discussing some of the key provisions in C-27 and their impact on innovation, the potential challenges organizations may face, and how to prepare from a best practice and tooling perspective. Here with me today are three esteemed panelists. I'll start by introducing Tiana Korvic, Associate of Norton Rose Fulbright. She is in the practice focused on technology, innovation, governance, privacy, and cyber security. She assists clients in preparing for and responding to security and privacy breaches, and regularly advises clients on a number of privacy matters, including regulatory compliance with provincial and federal requirements. Also joining me today is Carol Poivazan. Carol is a managing partner at I&Q Law and a global leader in artificial intelligence. She practices in privacy, cyber readiness, data governance, and AI risk management with a focus on ethical AI and responsible innovation. A seasoned former litigator and data co-lead for a national firm, Carol has been involved in multiple data governance committees for the federal government, national sector committees, the Global Partnership on AI, and acts as an advisor for several AI companies. Carol is co-editor of a newly released Thomson Reuters book, Leading Legal Digital Disruption, Artificial Intelligence, and a Toolkit for Lawyers and the Law. She is an adjunct professor at the University of Toronto's Faculty of Law, where she teaches on AI law and policy. And finally, Mark Rowan. He's the co-founder and CEO of Data Sentinel, a technology company specializing in automation and data privacy compliance and sensitive data management. Mark has been in the data governance, data management, and data privacy industry for 20 years, focused on helping organizations design, implement, and manage data-centric technology solutions. With Data Sentinel, Mark and team are bringing a core technology to the market, coupled with managed services needed to deliver outcomes needed for compliance. Welcome to our panelists, Tiana, Mark, and Carol. So I wanted to start today's session by just laying the foundation, because we've got three fairly hefty laws to talk about today. So in the last couple of years, we've seen jurisdictions around the globe enhance their privacy legislation, Europe's global GDPR being the most notable. And here in Canada, earlier this year, we saw the introduction of three new acts: the Consumer Privacy Protection Act, the Data Tribunal Act, and the Artificial Intelligence and Data Act, ADA. So I wonder, Carol, if you could start with us today and just discuss some of the key provisions in these acts and how they might impact RegTech firms and financial institutions, and more broadly, innovation.
Absolutely. Thank you so much for having me here. I really appreciate the opportunity to speak about Bill C-27. So let's start with the history. Bill C-27 is actually the government's second kick at the can of major privacy reform to PIPEDA at the federal level. Going back just a few years, we had introduced Bill C-11, which was frankly a scaled down version of Bill C-27, also dubbed the Digital Charter Implementation Act. And that's relevant because if you go back to 2018, the government undertook a series of national consultations on digital and data transformation that fed into what was ultimately a digital charter in 2019. Accompanied by a white paper for reform of PIPEDA. All of that has now sort of culminated into a series of draft laws that we are eagerly anticipating the determination of. Fast forwarding from what was Bill C-11 into what is today Bill C-27, it's important to remember that this is an omnibus bill, which means it doesn't just include one piece of legislation. It actually packages together 3 different pieces of legislation, all of which are very important to the overall innovation agenda in Canada. So the 3 different pieces, first being what would effectively repeal and replace PIPEDA, which again is the federal private sector privacy law, and it would introduce a series of new mechanisms that are really important mechanisms to not only modernize Canada's private sector privacy law, but also further align with Europe's General Data Protection Regulation, or GDPR, as you mentioned, which is very much held up as sort of the leading international standard for privacy law. It's important that Canada does this because for now, we maintain what's considered an adequacy status with EU, meaning data generally can flow safely from the European Union or the EEA, the European Economic Area, to Canada without requiring too many legal mechanisms in place. This is not true for such data going to the United States. So there's a real competitive advantage to Canada maintaining that adequacy status until the global community decides on something other than adequacy. And so in order to maintain that consistency, you have the introduction of the Consumer Privacy Protection Act, the CPPA, and that's the first of 3 bills introduced in Bill C-27. I'll start on that one, and then I'll move to the other 2 bills, taking each in order. The main changes in Bill C-27, or the CPPA component of it, is number 1, you have clarification on different mechanisms to collect, use, and disclose information outside of simply consent. So consent remains the dominant regime, but there are business exemptions that are baked into the CPPA that would enable certain exemptions for business activities, legitimate interest analysis that aligns with GDPR. And that's important because it may enable companies and different organizations to use data without necessarily going back and getting primary consent from the individual who gave up that data. These exemptions are limited. So they are not broad. It doesn't mean it blows open the consent regime, not at all. It's still the dominant regime, but they are important to consider in your overall assessment. The other important requirement from an operational perspective is that there is a codification of a privacy management program. It's always been best practice in Canada, but that's now being baked into the law to say accountability is not just a principle, it's actually a regulatory requirement. And you need to have in place what we call a PMP, a privacy management program that is effective, accountable, and responsive. Just a few additional really important points. We have new individual legal rights that are being introduced in the CPPA, a right to data mobility. I can take my data from one provider and move it to another, a right to deleting that data under certain circumstances. We see greater clarity, if you will, on de-identification. I say that with a little bit of a grimace because I think there are still lots of questions around what are the standards for de-identification versus anonymized data. And we can certainly talk about that in the question period to the extent that there are questions about this. We have clarity, or we have new requirements around the use of automated decision systems. This is super important because the definition of an automated decision system is very broad. It encompasses anything from a rules-based system through to a neural network. You can appreciate that that's a wide spectrum, and it's anything that sort of influences the judgment, human decision-making judgment. And there are 2 positive obligations to that, which means if you're using something that is classified as an automated decision system, You have to be able to explain that decision where it has a significant impact on an individual, and you have to maintain an inventory of those systems. So that could be some real legwork that needs to be done if this bill is passed. I'll end on one other note before I move to the other two bills quite quickly. There are stronger protections in place for kids. So for the data of minors, and really requiring that data to be treated as sensitive data, and enabling greater controls over that data. So those are some of the sort of high level requirements that we see coming in. We see much stricter enforcement requirements that actually segues really nicely to the second bill around the new creation of a tribunal that would have oversight mechanism for limited violations of the CPPA, enabling stricter control, enabling stricter fines, and opening up the possibility of a private right of action, an individual being able to sue for certain violations, that residing in part with this new tribunal. The last bill is the Artificial Intelligence and Data Act, and that is a new bill never to be found in the old Bill C-11 that specifically talks about the regulation of high impact AI systems. All of this, where ADA or the AIDA is valuable is that it establishes the bare bones of what the regulation of AI will look like in Canada. Where it's being criticized is that it is so bare bones, we don't even really know what it's doing or what it's about. And also there are some questions, some pushback on the extent of oversight that the minister has. But at its heart, what it's trying to do is establish key accountability mechanisms in place for high impact systems, and ensuring that there's a degree of auditability of not only the processes that govern those systems, but the technology that administers those systems as well. I'll stop there.
Can I ask you a quick question on that before you do stop, Carol? My impression of the element that you're discussing relative to high impact systems is that that's not defined in any meaningful way at this stage.
No, it's not. It's subject to the regs.
What that means yet, and where that's going?
Yeah, absolutely. We have a sense because you can draw. So Canada is actually it's probably the third major jurisdiction to table draft AI law. The other two major jurisdictions, the European Union, absolutely, with its Artificial Intelligence Act, it is an advanced, prescriptive, comprehensive draft law that would govern what they call high risk systems. And they give a specific definition as well as examples, like sectoral examples. So, what the Europeans have done is they've created this pyramid of criticality that says, there are some technologies that are just prohibited, and there are some that are considered high risk. So for instance, in the employment space, financial services, healthcare, they're providing greater guidance about what that high risk means and what it looks like. You can draw inspiration from that to better understand what high impact in Canada looks like. In addition, the AIDA specifically defines bias and harm as two considerations. So looking at psychological harm, human harm, physical harm, and that helps also give guidance as to what high impact means that will sort of help us determine what this law is really trying to govern. And then there's a lot of sort of academic, civil society, industry-led research that is better shaping what the concerns really are with AI systems. And I think that, again, you can draw inspiration to better understand where the regulations are likely to go and how they're likely to define high impact systems here in Canada.
Yeah, that's it's interesting. I think you read my mind, Mark, in terms of the question, because I was thinking, one of the concerns we often hear from members is harmonization, like across jurisdictions. And we've been hearing a lot about definitional differences. I wonder if Carol or Tiana, you might want to just give us a bit of a view on the definitions, consistency across the Canada and the US and Europe. Is it highly divergent, or are they close? Just some sense. Tiana, do you want to start and see?
Yeah, So I'll talk a bit about CPPA specifically and how it measures up against the GDPR. And kind of how I want to break that down is what are the similarities? What are the notable similarities between the two that is also new under our federal privacy law proposed under Bill C-27? What are the differences and why we're seeing these kind of parallels being drawn? So from that first point, the notable similarities we're seeing is, for example, new rights that are being explicitly legislated under our new federal privacy law, like the right to be forgotten, as Carol mentioned. So individuals now under CPPA would have the right to request disposal of their information. And under the GDPR, the term is erasure. In circumstances where it is no longer necessary, consent is withdrawn, or the information has been unlawfully possessed. So if you actually look at the two provisions side by side, they draw very similar language, almost identical in certain circumstances. And a lot of these pieces are not necessarily new. So under PIPEDA, we already had a requirement to dispose information when it's no longer necessary for a business purpose, but now we also have it codified for disposal rights. On the other hand, consent can be withdrawn. Individual can withdraw consent under PIPEDA, but now we also have it subsumed under this right to be forgotten. Another big and notable similarity I see is the breach reporting requirements for service providers. This is new under CPPA. Initially, PIPEDA only applied for breach reporting to organizations that control the information. It didn't extend to those third parties or service providers that are processing it. And so now it's bringing in this new level of accountability to third parties that had initially fallen outside the scope of PIPEDA. And we see this language also into the GDPR, where it requires to notify organizations as soon as feasible where their information is involved. Similarly, under CPPA, it's without undue delay. So what that means is organizations, they still maintain control over that data in terms of responsibility. They're required to safeguard it and fulfill notification requirements to the appropriate data protection authorities and individuals. But now there's this added layer of accountability to third parties. And then that kind of brings me to that second point, which is what are the differences? And I'll focus a bit on the data transfer. So GDPR really looks to the recipient country in terms of comparable measures to the GDPR. So it looks at their privacy laws, so to speak. Meanwhile, we have CPPA, which looks to the organization that is receiving the information. Do they have comparable level of protections to the organization that was initially in control or that maintains control over that information? And so why is this important? Well, as Carol mentioned, there's this adequacy status under the EU, where the EU Commission is, they review countries' privacy laws to see whether it's up to date with the technologies, whether it's comparable to the GDPR, and where you reach that adequacy status, there's a big advantage. Data can flow freely from the EU to Canada, especially when you're dealing with sensitive information and financial institutions that handle, quite frankly, a large volume of relatively sensitive information. They don't have those restrictions for like that non-recipient countries who are not comparable in GDPR measures. In those cases, you're required to put in place things like standard contractual clauses, for example. And so why is this important? Well, Bill C-27 is well timed because every 4 years, typically our adequacy status is up for review. And so I think that's part of the reason we're seeing so much parallel in those languages between the CPPA and the GDPR that is present under Bill C-27.
Thank you, Tiana. That's really interesting. I didn't know that that syncing up with the adequacy. In terms of the AI, if we go back to AI and something that Carol mentioned earlier, in terms of the AI framework, if PIPEDA is the overarching legislation, do any of you have a view on how the regulatory bodies within Canada will interact with PIPEDA? We were in an offsite last week with some members, and there is some concern in terms of what is it going to mean, and if there's going to be some fragmentation, and what that could mean in terms of implementation and creating a strong governance framework at an FI level.
Carol, you're probably best suited to take that one. Sure.
I'm happy to take that on. So ADA is, as I said, it's a bare bones federal law. Its application is restricted in certain parts. So many government departments do not fall within ADA, but otherwise it seems fairly broadly. It seems to apply fairly broadly. But as I said, it is fairly bare bones. So when you're looking at the meat of ADA, a lot is left to the regulation still. We're still waiting to see what specifically the mechanisms will look like in terms of what the requirements are, what the oversight will look like, what the office of this new data and AI commissioner will look like. It will be a deputy minister level. It will not be a separate sort of ombuds role, but there's a lot still that needs to be determined. In terms of fragmentation, that's a question both sort of at the national and provincial level versus the international level as well. So we do see different sectors that are taking on more of a role to govern artificial intelligence. We've seen this in law enforcement. We see it in healthcare increasingly. We definitely see it in financial services. OSFI has undertaken a number of sort of workshops, as one example, a number of workshops to sort of re-energize and modernize their guidance around the use of technology by financial institutions. And the output of that will be seen, I think, shortly. I think it's into early 2023. So there is certainly greater guidance to the sectors, various sectors, in terms of what it means to have a responsible AI program and use artificial intelligence in a responsible manner. And it will have to fit with ADA to an extent if it's passed, given that ADA seems to have broad applicability. Now, where ADA fits, so to that extent, there is a risk of some degree of fragmentation within Canada, also that it's federal law. And the question will be, well, how do provinces ultimately regulate this on their own? We've seen different provinces take this up in terms of a trust framework. Ontario has an AI trust framework, for example. And so we can expect that we'll see a little bit more of that throughout Canada. In addition, when you look at Quebec's privacy law, it specifically bakes in certain requirements around automated profiling, again, aligning very much with GDPR, but having an impact on the community, the artificial intelligence community. Vis-a-vis the rest of the world, we are very much pushing at multilateral levels, pushing for more consistency in the way that artificial intelligence will be governed. It's very difficult to govern a technology on a fragmented basis. And so there is a degree of alignment, at least conceptual alignment, between Canada and the EU. The US is taking a slightly different approach in that it's favoring more of the self-regulation. So establishment of various standards and sort of guidance documents that are coming all the way from the White House. We saw the White House publish a draft Bill of Rights on artificial intelligence, as well as we're anticipating NIST, the National Institute for Standards and Technology, to publish their AI risk management framework in early 2023. So they're taking more of a self-regulatory approach by offering guidance and standards. That having been said, if you look in the US, you have fragmentation from city through to state and federal. So you have city law in New York, local law 144, that's governing the use of artificial intelligence in employment and recruiting. You've got then state level laws that are coming out, such as Illinois, also in that sort of employment space. And then you have two different federal laws that either explicitly seek to govern artificial intelligence or implicitly, or well, it's explicit, but not as its own standalone law. It's as part of a privacy law where you see governance of algorithmic accountability. And so Canada is very mindful of the more prescriptive nature of the EU, the more self-regulated nature of the US, and those are some of our major markets that we're playing with. Our companies still need to be competitive while being safe. So fragmentation is happening. It is happening in the AI space, and we have to be mindful that it's happening within a context of privacy law as well.
Yeah, because the complication with that is if there isn't common definitions, just even on the basis of AI risks, then you aren't governing at the same level, like by default. Because if you have a different definition of bias or a different definition of explainability across governing agencies, like it makes it very, very difficult for implementation. We're certainly hearing that from our end, like from the FIs and the reg techs, because they got to build on something that is very, very fluid, and risks like bias especially are very, very real. And if there isn't a common definition, and now you're saying there's one in AIDA, well, will we see something at the OSFI level and FSRA and that is consistent? Because we don't see that. We're gonna have a bit of a problem in terms of actually the implementation, sharing data and actually how you manage your models.
And I just want to add something to that, though, because we're still very early on in the regulation of artificial intelligence. And so whenever I'm asked the question, what do we do about this complexity of different jurisdictions? There are consistent themes that we can look to, especially now that most law is not passed. There are themes around sort of data assessments and prevention of bias, demonstration of a comprehensive, good quality data set, an impact assessment to understand the use of the AI system in context, effective stakeholder engagement to facilitate that, a robust testing of models to ensure they are safe, secure, and properly constituted for the intended purpose. And then certainly a number of considerations on the output side. How do you ensure that throughout the life cycle of the AI system, it is being used as intended, that you have sort of thought through some of those unintended consequences and mitigated against those risks, and that you've properly established liability in some of your contracting. So yes, there is complexity, but you can simplify that complexity if you know what the international trends show.
Mm-hmm.
And if I could add to that, there's this common baseline, I think, is what Carol's alluding to, that is we can assume is going to be the case based on what's happening in other parts of the world, where technology is already being developed today to be able to address those kinds of concerns and challenges relative to compliance. And we are seeing emergence of new technologies now in Europe, throughout North America, and I'm sure globally as well, where organizations are assuming what the outcome of this legislation is going to look like and are already creating those technologies today. The other thing I want to talk about is the potential avenue of leveraging those kinds of solutions now, prior to that regulation potentially becoming real, even if it does or doesn't, right? Because at the end of the day, we don't yet know. But it's still good corporate activity that is probably in the organization's best interest to start to use these kinds of capabilities that are evolving in the marketplace to protect the organization from potentially litigation. As I'm assuming, as consumers become educated, they're going to understand what a company can and can't and shouldn't do with their data and or their decision making that potentially impacts them.
Especially in more litigious societies like the US, where the class action bar is already coagulating around some of the opportunities to move against companies that are displaying biased, outputs from their algorithms. It's really important what you're saying, though, because when we talk about regulation, we're always thinking about, like, is it privacy? Is it AI?
Mm-hmm.
But you can also look a little bit differently at what you always go back to, those, like the primary concern. What are you protecting against? What is the harm you're worried about? And so even if you look at it from like a diversity and inclusion perspective, where there's a lot of emphasis on making sure that you are enabling people to everyone to bring their best to themselves, so that you have a properly, like a good, diverse company. If you're using systems that are you don't even know that they're biased against certain groups, you're undercutting your own principles and your own values from a D&I perspective, or potentially in some of your ESG reporting. So there are really, when you think about what the law of artificial intelligence is trying to protect against, it infiltrates different areas, which makes it not just a good thing to do, but increasingly a must-have AI governance program to ensure that you're not inadvertently undercutting your own interests and your own principles.
Mm-hmm.
Yeah, the AI governance is, like I said earlier, is a very key topic with us. And one of the areas we're honing in on is around the data transfer, right? With third parties. So you're using third parties, more, there's usually movement of data. And what does that mean? Like, you start thinking about applications like AML applications, or when you think about that, most global firms are, cross jurisdictional. So what would be the impact, of this data sharing? So I wonder if you might just expand a little bit on that, like in terms of what you're seeing in terms of best practices, how organizations are starting to position themselves, taking into account these new privacy laws. And maybe, Mark, also if you had any insight into some of the tools organizations are starting to look at to stay compliant, but still not stop this data transfer that is needed for so many different applications in the financial sector.
Yeah, happy to share on the technology, and then hopefully Tiana and Carol, you can chime in on some of the legal elements associated with that transfer process. On the technology side, you look at bucketing across C-27. There's different elements that are described. From our perspective within our organization, we talk about governance and we talk about data governance in general terms, but then the expansion of the definition of that, especially relative to what's going on with PIPEDA and how that's going to impact an overall governance program within an organization. And then thinking about how we help organizations automate those processes, because in most organizations that are mid-sized to enterprise level, the data sets are massive and they are distributed across third-party systems. They're distributed in different global footprint. They're structured, they're unstructured. There's areas of data that is very well known and very well governed. And then there's areas of data within most organizations that is dark. We don't know what's in those holdings, all of which presents a certain amount of risk and makes it way more challenging to actually technically govern those data holdings. However, the good news is the technologies are evolving around the world right now that allow us to do things like track, trace, inventory all your PII, all your PCI, your PHI data that exists within your organization or what your company deems to be sensitive. So you can at least today understand where all that is and understand whether it's compliant with your policies, et cetera, in, we'll call it near real time across an organization. So that's good. The ability to be able to categorize those data assets across the organization and understand what that data is using technology to be able to do so. That's table stakes today, given what's evolved across the footprint of technology. What's really interesting is how we now bridge that across into ADA and our ability to be able to do things like measure bias in data. Again, automating those processes using technology and doing it with distributed data sets that might have different exposures to different regulations around the world, and treating data differently depending on where it originated or where it's held. And how the company wants to obviously manage those policies. Those technologies are evolving now where we can help organizations do things like measure bias. But now take it to the next level where you actually now to start to report on that as frequently as is necessary for compliance. We don't yet know what that means, but TBD. And the ability to be able to manage processes across the organization and using technology to do that to ensure that the organization is managing these risks effectively. And then, of course, having transparency and the ability to be able to prove it, be auditable across every segment of C-27 that we've talked about so far relative to CPPA and to ADA specifically. So that's really cool. The technologies that exist today are being adapted to be able to do what I just described relative to bias, et cetera, within AI models, including the concept of investigating the model itself and understanding whether there may be nuances built into that model that need to be addressed, generating outcomes that may not be appropriate based on the decision-making that's being made. Those are pieces of the puzzle that are being developed today that I think most organizations that have volume and complexity in their data are probably going to want to investigate.
Who's typically accountable for that type of program at an FI? Like, because that what you described would touch so many senior people, chief privacy officer, CIO. Like, who has ownership of something like that?
That's evolving as well. What's
Yeah.
interesting in our client conversations, we may start off with a prospect who could be a CISO, could be a data privacy officer, could be a CIO, but eventually they all show up at the table at the same time. And then I've been on calls with a bank in particular, a Canadian bank in particular, where there was an actual debate on the call as to who owned the problem. It didn't get resolved on the call. Eventually it will be resolved. So I mean, clear ownership, sorry, I forgot to mention risk and compliance.
Yes.
And of course, the attorneys within the organization as well are going to have a say in how all of this gets managed. It's not clear to me.
Yeah, I'm curious if those bank participants wanted the accountability or didn't want the accountability.
There's a lot of finger pointing going on.
Yeah. Tiana, Carol, do you have anything any other best practices you've seen as you've talked to your clients?
Yeah, and just to build off a bit about what Mark said about data mapping, you know, it is in the realities of today's world where we're transferring large volumes of data. And when it comes to the CPPA and access requests, even where you're not required to obtain consent to transfer to service providers, you will still need to disclose, for example, the names or the types of third parties that are receiving the personal information. So it is important to know where that data is moving around and who has it for what purposes. In terms of other best practices, I'd say retention periods and contracting very clear retention periods are extremely important. You should not be storing data any longer than is necessary to fulfill the purpose for which it was either collected or transferred. And I think one key component is don't forget about emails. I think emails get overlooked a lot, but it's such a common form of communication where we transfer high volumes of data. And when it comes to, for example, financial institutions, it's very sensitive data that is being transferred. So don't have emails in perpetuity. They should have retention periods. And in that same token, that data, there should be mechanisms where you either dictate that it's going to be returned after a specified amount of time or securely destroyed. And the key word there is securely. It's not going to be enough to just ask or make a request for a data deletion. You need to ensure that the manner of disposal is secure. And on top of that, you have to ensure that it was carried out. So it might be prudent in some cases to ask for a certificate of deletion. Another best practice would be to use safeguards in your contracts or in engagements with third vendors. So avoid vague language like appropriate safeguards. Replace it with quantifiable security standards like PCI standards when you're handling payment card information, or NIST, or encryption, or firewall, or MFAs. Stay away a bit from the vague language. I think we tend to see that, or at least did see that a lot in contracts where you set out have appropriate physical, technological, administrative safeguards, but we don't necessarily know what that entails. And then I think the third tool would be to contract notification requirements. We do see that CPPA mandates that these third-party service providers notify where there is information that is subject to unauthorized access or disclosure. But the first component there is the timing is not prescribed. It's really as soon as feasible, which could mean a loose definition. You might want to include something more concrete so that you can mitigate any harms depending on the type of information. And the second component to that is that you typically deal, and it's not, we see this a lot, is you're dealing with vendors that are outside of Canada, not necessarily even the US, but sometimes in Europe or elsewhere in the world, and they're not necessarily familiar with the Canadian privacy laws, which has that section mandating notification. So as a best practice, contracting those requirements, I think would be a good step forward. So the retention period, safeguards, and notification requirements.
If I could add to what you're just saying as well, you think about data minimization in a general term and how technology is being developed and is evolving now to be able to automate processes relative to discovering data that is rot or redundant, outdated, or trivial data within an organization, and automating the process of determining the aging of data, and then obviously taking action on that depending on the policies that the organization wants to maintain. That exists as well. And the ability to do things like deduplicate data that might have perpetuated itself throughout an organization, especially in email systems, to your point. So a little war story, if I may, without naming a client. One of our customers had an incident, and the incident was specific to their email system, but it was not their system that was exposed. It was a vendor, a third-party organization, and in this case, a travel agency that they had been using for 15 years, and they have a global footprint of employees, global data set. And unfortunately, all the emails over that 15-year period of time where people were organizing travel were exposed in this incident, including images of passports, credit cards, social security numbers, US-based. So every piece of personal, valuable information you could possibly imagine disappeared in minutes. And so the shock of what's in those email systems was obviously a bit of a surprise to them, but it's consistent across, I think, most organizations around North America.
Yeah, there's so much to unpack. Like, we could probably have like a series of 6 of these sessions. When I think our stakeholders in the CRTA are regulators, reg tech firms, and financial institutions. And I want to kind of close on some advice from the 3 of you for one or multiple of those 3 stakeholders in terms of how they should prepare and how they should think about it, because we're combining a lot in 3 acts, you know, the privacy element, the artificial intelligence element. So if you had some advice to one of these stakeholders or more, just explain what you would get, how they would prepare for this change. Maybe I'll start with Mark.
Sure, why not? There's a pause there. We get asked often, what should I do first? How do I tackle this monster, this elephant? And we usually start with, let's bite it off one piece at a time. And we usually suggest that we start off with an automated data mapping exercise or an inventory of sensitive data throughout the organization. And typically what that means is you get to see the good, the bad, and the ugly of actually what's in the data across your holdings. And that informs your policies, your procedures, your security controls, your data governance program, your privacy program, and then everything related to obviously compliance and compliance reporting specific to the things that we're talking about today. So we typically advocate for that as a first step because you can truly understand the problem set after that.
Yeah, I can jump in there as well. So I think the way to plan really is threefold. Would be review, plan, of course, and then action. Under review, you know, looking at Bill C-27 and especially CPPA, a lot of this isn't new. We're just codifying existing guidelines and practices that have already been published by the Commissioner's Office. So not much is new. So the best kind of foot forward in terms of reviewing would be to look at your policies. Are they up to date? Do they have the relevant 10 FAIR principles that we see across all our privacy laws? Data map, figure out where your data is being stored. And again, deduplication is extremely important because we often see data being moved around where we don't necessarily expect it to be. And data retention periods should always be reviewed and ensure that they're enforced. It's not enough to have a chart that sets out when certain items will be removed, disposed, discarded securely, of course. You have to actually implement and action those items. The second part would be to plan. So vet the third-party vendors that you're transferring data from. Also clarify their roles. What are they actually doing in the scope of your organization? Are they handling a large amount of data to deliver products and services, or are they actually developing those products and services? And if so, is there an AI component to it? I think it's extremely crucial to understand what their safeguards are as well as their role, because that will have a role to play under the CPPA and IDA. And then the third item would really be to action. So action items based on their priority levels. If you see that data is fairly outdated and being held in perpetuity, maybe that's a high priority item. You can't do everything at once, so it's best to kind of tackle one beast at a time.
Oh, thanks, Tiana.
And I think the advice so far is great, and I think you should follow all of them. I'm going to add a little bit of a higher level because I want our, data is an asset. It is it is a liability for sure, and you have to treat it very carefully. But it is also a huge asset for a lot of our companies, and so thinking strategically is super important. When I start with my clients and they come to me and they say, I need a privacy management program, I always say, okay, great. Start by telling me, what are your data ambitions? Where are you going? Like, let's not just talk about the here and now, because that will restrict how you create your program, but tell me about where you're going. And then let's build a program that matches those ambitions. So it's super important to think about the integrated component of data, the privacy, the security, the uses through emerging technologies, and apply a strategic lens to your governance so that it's integrated and it's not a number of friction points as your product and business teams are trying to innovate. That's not the point. That's not going to get you anywhere. So having that multidisciplinary team to sit down together to determine from the ideation stage straight through to implementation, what are some of the ethics questions? What are some of the privacy considerations? What are some of the impact questions that we need to put in place? And then having that carry through the life cycle of that system or that project or idea is a recipe for success. If we think about data myopically and we say, well, it's about privacy, it's about security, but we're never going to get to a point where we can actually really leverage the value of data in a safe and responsible manner. So my call to action is, by all means, blue sky it. Be ambitious about what you want to do with your assets, and then work from that ambition to build a privacy management and integrated data and AI management program that will allow you to safely realize those ambitions.
Yeah, that's excellent. I just have a little question just in terms of practicality. Are you seeing data governance and AI governance? How are you seeing that interact within organizations? Are you seeing it commingled or separate, or?
Yeah, I see them coming together. When I see this more in the US, where they're much more aggressive about their use of artificial intelligence, where they're not creating AI programs, they're creating data and AI programs that are brought together to do their PIAs at the same time as a threat risk assessment, at the same time as an AI impact assessment. It's all being thought of together, which is, I think, a really effective way of doing it.
Yeah, I totally agree. By the way, we're seeing exactly the same thing, and again, mostly US centric today, but that will evolve in Canada. I'm 100% confident of it. And it is a blending. It is a life cycle of data within the organization, and it's governing that across the entire life cycle through AI, obviously, in consumption of analytics, but also at the creation of data or the importing of data or the purchasing of data, and how it is governed across that complete life cycle. And that's what's cool about the technologies that are evolving today in the market, is that they are now evolving to the point where they're trying to address the entire life cycle, no matter the kind of data or where it is.
That's perfect. Well, thank you so much. This was a really enlightening conversation. I'm sure our members are going to really enjoy it. Thank you, Carol, Tiana, Mark. Thanks you, Data Sentinel, for sponsoring. I hope you all have a good rest of the day.